Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 4 of our new program entitled What is an Injury? And we're specifically talking about what is an injury as injury is defined in the California Workers' Compensation System. And the purpose of this program is to help you arrive at accurate opinions on AOE, COE, industrial causation, in your very next evaluation that involves a denied claim for which you are hired as the qualified medical evaluator to render a compensability determination under Labor Code 4060. And this primarily applies to those cases that come to you as denied cases. But of course, accepted cases also require, in many instances, an AOE, COE determination from you, as the parties ask you to recapitulate or restate your understanding of industrial causation in the particular claim that you're called upon to evaluate. And the process of rendering accurate opinions and accurate determinations on AOE, COE, industrial causation begins with understanding some of the behind-the-scenes processes, procedures, rules, regulations, etc., that are going on behind the scenes with the other parties involved in this claim, that then, because of those behind the scenes processes, brings the case to you for your medical determination. Now, many times you don't have to get involved with legal matters. You don't have to get involved with administrative matters. Your concern is with medical determination, but an understanding of the behind the scenes administrative processes that bring this case to you are necessary for you in order to be able to provide an accurate AOE, COE determination, because the better you can understand the behind the scenes processes, the better and more accurate and quicker you can arrive at the correct determination in every single case. And in this program, we're sharing with you many tools that you'll have in your tool chest the next time you come to a difficult AOE, COE determination. So I have a fascinating series of discussions throughout the course of this program. Today we're in session number 4, and let's just talk about where we've come so far in this program before we get into the topics of today's discussion. In session 1, we began with some basic definitions that are involved in the AOE and COE determination. And one of the most basic definitions of which you need to have an excellent and thorough understanding of is the concept and the definition of injury, as injury is defined in California workers' compensation. And this is critical because many times in these denied cases, the reason that we're hired as qualified medical evaluators is to answer the question as to the presence or the absence. In other words, doctor, is or is there not an industrial injury present in this case? Well, it's very, very interesting because in order to have an industrial injury, we must first have an injury. Without an injury, there can be no industrial injury. So it's very, very important that you understand the exact definition and concept of injury as injuries defined in California workers' compensation. So injury is very broadly and loosely defined in Labor Code Section 3208, and we talked at great length about that, and then we transitioned into a discussion about AOE. And it's important also that you understand the exact role that you're being called upon to participate in as a qualified medical evaluator. Your role is to render opinions on AOE. You as the qualified medical evaluator, you do not render opinions on COE. COE opinions are reserved for the trier of fact, which is the judge. Your job as the qualified medical evaluator is to tell us AOE issues. So we defined very, very clearly the definition of AOE. And we went over a couple of very, very interesting cases that illustrated the principle that in order for an injury to be compensable under workers' compensation and for benefits to be delivered, The injury does not need to be of the kind anticipated by the employer, or it does not need to be an injury peculiar or specific to the employment. And we went over a couple of cases that illustrated some atypical injuries unrelated to the workplace duties, but that were found to arise out of the employment and were therefore compensable injuries. So it was a very, very fascinating concept, and several other concepts that we discussed in session number 1. In session number 2, we built upon some of these definitions and some of these basic concepts, and we talked about the distinctions between exacerbation versus aggravation. We talked about the dates of injury for both specific and cumulative trauma injury claims. And this is something that you need to be very, very familiar with for approximately 4 to 5 to maybe even as many as 6 out of your very next 10 cases. You need to understand the concept of the date of injury for cumulative trauma injury claims, because many, many examinees are going to come to you with denied claims for an allegation of cumulative trauma, and it's the date of injury in those cases that allows these cases to succeed, survive, and thrive when they would otherwise be defeated by law. And it has to do with a nuance related to the date of injury for cumulative trauma injury claims. Then we spent a great amount of time on Labor Code Section 3600, also known as the conditions of compensation liability. And it's a very, very fascinating section of the law which you should review approximately at least every 6 months just to stay familiar with the various sections. Sections 1 through 3 deal with the employee's burden of establishing industrial injury. If the employee can demonstrate or establish that sections 1 through 3 are present and operative in their injury claim, then the claim can go forward and be accepted. Sections 4 through 10 of Labor Code Section 3600 talk about the employer's burden. If the employer can establish one or more of these so-called affirmative defenses, then the claim can be defeated. And then we spent or in session 2, we introduced the concept of the post-employment claim. And we talked in all of these sections about the variable burdens of proof. Remember, a basic principle, not only in workers' compensation law, but in all law in general, is that the person or the party holding the affirmative of the issue has the burden of proof of proving the issue. So for an industrial injury, the employee bears the burden of the affirmative of the industrial injury, and the employee bears the burden of proving industrial injury. In sections 4 through 10, if the claim is going to be defeated by the employer holds the burden of proof of establishing that the claim should be denied based on one or more of these affirmative defenses. Similarly, in Section 10 regarding post-employment claims, we see this variable burden of proof where one party at one point holds the burden of proof, the employee, for example, and then at another aspect of trying to defeat the claim for industrial injury, the employer bears the burden, and there's these oscillating ping-pong rally back and forth of the burden of proof. And this is a concept that's going to repeat itself as a recurring theme throughout session 3, which we'll review in just a moment, and even today into session 4, and through the remainder of the sections of this program. There's this oscillation of the burden of proof, and we'll talk about each of the parties' particular burdens as we go over each of these concepts throughout the remainder of this program. And then in session number 3, we began by talking about the most fascinating of all the sections of Labor Code Section 3600, and that is Section 10, which deals with the filing of industrial injury claims when the filing is done after the employment separation of employee from employer. These are known as the post-employment or post-termination claims. And we learned, and this is fascinating, that under Labor Code Section 3600, in general, the filing of claims post-termination is barred. It's blocked, it's banned, it's prevented. These types of cases and claims are denied by law. The law is Labor Code Section 3600, Section 10. So post-employment filing of claims is barred. However, there are several exceptions to this bar, and the purpose of the exceptions are to protect injured workers who actually are injured on the job and have an injury arising out of employment, but for whatever reason, and there could be any number of reasons, for whatever reason, the claim was not filed until after the employment relationship had been terminated by one or the other parties. So there are actual instances when legitimate injury claims are just not filed until after the employment relationship has ended. And the exceptions exist to protect those persons suffering bona fide actual injuries in this particular scenario. And we went over several of these scenarios, the most significant of which, in my opinion, for us as qualified medical evaluators to understand is the post-employment cumulative trauma injury claim. And your job as the qualified medical evaluator in these claims is to, number one, understand what's going on behind the scenes and the rules and the regulations and the laws that govern the progress of these claims throughout the life cycle. That's important to understand, number one. And then number two, it's important for you to understand your specific role in providing your AOE opinion in these cases. And we'll review in today's session exactly what is the AOE determination and what is the algorithm through which your thinking process can progress to arrive at an accurate conclusion in every single case. This is a foolproof algorithm that you can use in every single case that will land you on the proper and correct and accurate determination every single time. And we'll review that as we go through today's discussion. Now, in today's session, that brings us to today's session. Today's session, I want to continue with some very important concepts that are now going to start to bring to practical application some of the concepts that we've already established throughout our first three sessions. And I want to begin by talking and reminding you how the concept of liberal construction pervades every one of our opinions, every one of our conclusions, every one of not only our decisions with regards to this particular examinee, employee, or injured worker, but how liberal construction is applied to each and every law that governs workers' compensation in the state of California. From there, I want to transition into some concepts related to reporting of the injury, And as we're going to see, the burden for reporting an industrial injury falls upon the employee, and every single employee will get into the record one way or another, either into the written medical record, or they will tell us at the face-to-face evaluation that they reported the injury. We'll review some of the scripts that employees use in describing how they reported the injury, and we'll talk about the laws that actually describe what constitutes proper and improper reporting of the injury. And then we'll talk about the $10,000 rule, which if you can understand the $10,000 rule, you'll understand why you see so many cases that come to you as denied cases for your AOE determination. So this is very, very fascinating behind the scenes stuff that bring these cases to you. And then again, we'll review the causation algorithm and show you exactly how you can handle these cases that come to you on a denied basis. Okay? So with that as our introduction, let's begin the topics of today's discussion. And today we're in session number 4 of our new program entitled, What is an Injury? Okay, so let's begin by talking about the concept of liberal construction as that's defined in California workers' compensation law. Now, this may be something that you've heard about. You may have read something about liberal construction, and you may have heard that in layman's terms, basically, that the concept of liberal construction is that the tie goes to the runner. In cases of disputes, in cases of close calls, the tie goes to the injured worker. The tie goes to the runner, similar to in baseball. Well, that's basically an accurate way to consider the concept of liberal construction. And liberal construction is defined in Labor Code section 3202. So let's read exactly from this section. It says that this division, and I'll explain that in just a minute, this division and Division 5, which are various divisions of the Labor Code that deal with all of workers' compensation law in California, commencing with Section 6300, shall be liberally construed by the courts for the purpose of extending their benefits, meaning workers' compensation benefits, for the protection of persons injured in the course of their employment. So let me elaborate on this a little bit. I don't know if you have the book, Workers' Compensation Laws in the State of California. I have the book. I don't have it with me. I wish I did. I would show it to you. So let me just illustrate with my hands and my words about this concept and about this book. When it says here, this division, they're referring to Division 4. So they're saying that Division 4 and the very next section of the workers' compensation laws in the state of California, Division 4 and Division 5, commencing with Section 6300, all of these labor codes. Now, Division number 4 begins with Labor Code Section 3200. So here at liberal construction, we're talking about Labor Code 3202. This is only two codes, two labor codes, into all of the codes, labor codes, that are governed by liberal construction. Now, Division 5 begins with Labor Code Section 6300 and ends with Labor Code Section 9104. So from 3200 to 9104, all of those hundreds and thousands of labor codes that govern workers' compensation in the state of California, all of them, thousands of codes, are governed by liberal construction. What this means is that all of the laws that govern workers' compensation in the state of California shall be liberally construed for the protection of injured workers. All of the laws shall be liberally construed. And we've illustrated this principle throughout our first 3 sessions of this program, and we're going to continue to demonstrate the operation of liberal construction throughout some of the cases and throughout some of the laws and regulations that we're going to discuss throughout the remainder of this program. So this is an important concept for you to keep in mind, that here in the state of California, we have a liberal construction philosophy such that in gray areas of dispute, the tie indeed goes to the runner. And we're going to illustrate that principle, at least as relates to today's topics, related to reporting of the injury and the $10,000 rule, and how these cases come to us as denied cases for which we provide our liberal construction or our liberally construed AOE opinion in those cases to provide protection to persons injured in the course of their employment. So let's talk about this concept and the concept of reporting of injury and see how these two concepts interrelate to provide protection for injured workers. Okay, so let's see how liberal construction can be applied to the concept of reporting of the injury. Now, reporting of the injury is critical because before there can be a claim for an industrial injury, an industrial injury or an allegation of an industrial injury first has to be reported by the employee. Without the reporting of an injury, there can be no industrial injury. So the whole process of establishing a claim for industrial injury begins with the reporting of the injury. And it's very, very fascinating. When you begin to review the medical records for your very next evaluation, and then when you actually get to the face-to-face evaluation with the injured worker will always tell you that they reported the injury. They'll say things like, I told my supervisor, I reported it to human resources, I put a note on the desk of my foreman, and they'll have all of these stories as to how they reported the injury, because reporting of the injury is the burden of proof of the employee, and there are proper and improper ways to report the injury. So reporting of the injury is described in Labor Code Section 5400. We're going to talk about 5400 and the next several labor codes after 5400 that talk about how the claim gets off the ground, how the claim gets initiated, how a claim for industrial injury, whether it's accepted or not, how it actually begins, and some of the rules and regulations and laws that govern the early minutes, hours, and days involved with the incident of an industrial injury. So let's read directly from Labor Code Section 5400. It says, except as provided by sections 5402 and 5403. So it starts off by telling us, before we tell you the law, we need you to know that there are some exceptions. So we'll get into the exceptions in just a minute, but let's go into the basis of this law 5400. It says, no claim to recover compensation under this division shall be maintained. In other words, the claim shall be denied, shall be snuffed out, shall be put out, shall be negated. It shall be negated unless within 30 days, a specific timeline, after the occurrence of the injury which is claimed to have caused the disability or death, there is served upon the employer notice in writing. So far just in this law, we know that there must be service in writing within 30 days. There's a 30-day statute of limitation with which to report an injury. And it must be reported in writing. Not only must it be reported in writing, it must be signed by the person injured or someone in his or her behalf, or in the case of death of the person injured, it should be signed by a dependent or someone in the dependent's behalf. So this establishes a burden of proof, and it establishes a very stringent burden of proof on the employee. Let's see how stringent it is. It's very stringent. It says you must serve notice in writing, number one. And how many times do you speak to an injured worker and you'll ask them, well, how did you report it? And they'll say, well, I had my wife phone it in. Or they'll say, my son went down to the plant and told the supervisor, and you're listening for some sort of service of notice in writing, and it seems to be missing, okay? So 5400 creates very strict requirements. Number one, that it be served in writing, that it be signed by the injured party or someone in the injured party's behalf, and then this notice must be provided within 30 days. So this creates a stringent burden of proof on the employee. Now, if you were the claims administrator and you received written notice signed within a reasonable time period, certainly less than 30 days, then you have some basis to make a decision whether to accept or deny the claim. But many times, injured workers do not provide notice in writing. How can this be? If 5400 requires that in order for the claim to be maintained, there be service of notice in writing, how can claims be maintained in the absence of written notice? Well, that has to do with some of these exceptions. So let's talk now about Section 5402. So Labor Code Section 5400 sets up a very strict and stringent burden on the employee. There must be written notice in writing. The written notice in writing must be signed, and the written notice in writing must be served within 30 days. Well, this strict requirement, which is established in law, for some reason, then goes on to have some exceptions which lessen the strictness, lessen the stringentness, and lower the threshold for the establishment of maintaining the claim for industrial injury. And these are the exceptions, the first of which is under Labor Code Section 5402, Section A. So let's read this. And this is important to understand because you're going to hear this scenario. If you pay attention, you're going to hear this scenario in many of your cases. So 5402 tells us that in the absence of a written notice served within 30 days, any knowledge of an injury, any knowledge obtained from any source, doesn't have to be from the injured worker, on the part of an employer, on the part of his or her managing agent, on the part of his or her superintendent, foreman, or other person in authority. And you can see that all of these are areas of dispute. Person in authority. Can you imagine that when an injured worker says, I told my supervisor about the injury, I told my floor manager about the injury, I told my co-worker about the injury. Can you see that the issue of the authority of this particular person to whom the injury was reported could be an issue in dispute? Of course it can. And all of these are issues of dispute. Or it says, or even the knowledge of the assertion of a claim for injury. You hear knowledge, you hear word around the floor, around the plant, around the warehouse that Bill, in receiving, is claiming an industrial injury. You hear this on the other side of the warehouse, that someone on the far side of the warehouse is asserting a claim for an industrial injury. This constitutes knowledge of the assertion of a claim. Any knowledge obtained from any source that's sufficient to afford the opportunity for the employer to make an investigation into the facts is equivalent to service under Section 5400. So isn't this amazing? 5400 sets this high bar for notice of the injury. Must be written notice, must be signed, must be submitted within 30 days. This high bar. And then 5402 basically drops the bar to the floor and says that as long as someone in authority at the workplace has knowledge, has heard of it, has been told, has had a post-it note put on their desk, has received a phone call from the son of the uncle of the brother of the injured worker, has knowledge sufficient to afford an investigation into the facts, then that constitutes knowledge equivalent to a written notice signed and served within 30 days. Now, to me, this seems a bit ridiculous to establish a high threshold and then lower it basically to nothing. But this is an example of the philosophy of liberal construction. And the purpose of this section of the law, 5402, is to protect and to provide benefits to persons injured in the course of their employment when the reporting of the injury may not have risen to the lofty ideal and high standard as described in Section 5400. So this is fascinating. You can see that this section of the law creates great dispute. Many disputes arise between the parties over the knowledge. The employer is going to claim, I didn't have any knowledge. No one told me that there was an assertion of a claim. Okay, you can see the position of the employer. And then the position of the employee is, oh yeah, I told my supervisor, I told my foreman. They didn't do anything with it, but I told them. And you can see that this creates variable burdens of proof on the parties to establish the affirmative of their particular position. And this is what brings a great number of cases to us as qualified medical evaluators. We don't resolve the dispute over these factual matters. Those are resolved by the trier of fact, but the cases come to us for a medical determination as to the presence or absence of an injury. Okay, so before there can be an industrial injury, regardless of all of these issues, before there can be an industrial injury, there must first be an injury. And even though there are disputes regarding the knowledge and the reporting, the parties still want to know from us, okay, so while we figure this out, is or is there not any injury? If there's no injury, the claim can die. If there is an injury, then the parties can then continue to investigate the facts and decide whether to accept or deny the claim. But this is what's going on behind the scenes to bring these cases to us, okay? So these sections of the law, 5400 and 5402, describe some of the sequences of events that take place at the inception of a claim. And you'll notice that we've skipped section 5401. So let's fill in the gap and talk about the flow of events through these labor codes, 5400, 5401, and then into 5402, and other sections in 5402 as well. So under Labor Code section 5400, the employee bears the initial burden of notifying the employer of the injury. Okay, so that burden falls upon the employee. Now, notice, written notice is not necessary when the employer already knows of the injury or already knows of a claim or an assertion of injury from other sources. And sometimes injured workers will tell you that, yeah, my supervisor was present during the injury. And so in that case, the supervisor has knowledge of the injury. So courts have decided that an employee's or injured worker's failure to give written notice, and this is an operative theme that you'll find in your evaluations, that your injured worker did not provide written notice. So their failure to give written notice has no consequence, strangely, if the employer otherwise gains knowledge of the injury. But if the employer does not gain knowledge of the injury in any way, and this is going to be the assertion of the employer that they had no knowledge of the injury, the employer is going to move to have the claim dismissed. And this is why we get so many claims for our opinion on denied claims. This is what brings these denied claims to us. So that's Labor Code section 5400. We went over that. That review talks about the written notice. Now, we did not go over section 5401, but basically I'll tell you that section 5401 says that once the employer receives knowledge of the injury or receives written notice of the injury, the employer is required to provide a claim form to initiate the claim for industrial injury. So that's what 5401 is all about. Once the claim form has been provided to the injured worker, then we go into some of the considerations of Labor Code section 5402, and I want to talk to you about some of those in the next remaining slides. So section 5402 here, section B, we just reviewed section A, which talks about knowledge of the injury. 5402B says, this is important for you to understand, it says that if liability for the claim is not rejected within 90 days after the date the claim form is filed under section 5401, okay, so we said 5401 has to deal with giving the employee a claim form to fill out the claim form. So from the date the claim form is submitted by the employee, which is a critical date, and I'm sure you can see that that date becomes an issue of dispute as well. But within 90 days of the date that the claim form is submitted, the employer then has 90 days to investigate the claim to decide whether to deny or reject the claim. Now, this is being recorded in 2023. This 90-day time frame has just been reduced to 75 days for certain classes of employees. Namely, we're referring to the safety and peace officers in the state of California. The legislators have reduced the time period, the investigation time period. They have reduced that time period they're putting more pressure on the claims administrator to make an early decision to protect our peace and safety officers here in the state of California. But for most workers, it's a 90-day period. And the injury shall be presumed compensable under this division if the claim is not rejected within the 90-day time period. So the claims administrator has up to 90 days to investigate the claim, to decide whether to accept or deny the claim. If the claim is not rejected in 90 days, then it's presumed compensable under this division. And this presumption is rebuttable only by evidence discovered after the 90-day period. So what that means is that if the claims administrator blows the timeline and the claim becomes presumed compensable under this section 5402B, then the claims administrator cannot introduce evidence to rebut the presumption of compensability. They cannot introduce evidence that could have been discovered in the first 90 days. They can only introduce evidence to rebut the compensability presumption with information that could not in any way, due to reasonable diligence, have been obtained in the 90-day time period. So this is another example of liberal construction. It's intended to protect injured workers. The point of it is that the claims administrator is pushed to get their act together, to do the investigation in the 90-day time period, and get all the information necessary from prior medical records, prior employment records, whatever is necessary to conduct a thorough investigation. They're pushed to get it together within 90 days. Now, the claim can be rebutted after 90 days, but only with new information that could not have been obtained in the prior 90-day time period. So you can see this creates another oscillation of the burden of proof here, where during this 90-day time period, each of the parties, the employee number one and the employer number two, are going to be pushing to prove the affirmative of their particular issues. Now, one of the ways that each of the parties, both the employee and the employer, or in this case we talk about the claims administrator, one of the ways that they investigate the claim is to have the examinee evaluated by us as qualified medical evaluators. And they attempt to get this done within the 90-day time period. So you will get a call and you'll schedule the appointment, hopefully within 45 days, 50 days, 60 days, in sufficient time to produce your report so that the claims administrator can remain within their 90-day time period to either accept or reject the claim. Now, you would think that this might create a terrible, terrible hardship on an injured worker, that they would have to wait for 90 days. Are you kidding me? 90 days? I have a broken leg and I have to wait 90 days for you to make a determination as to whether or not this is an industrial injury. What do I do about my broken leg in the meantime? Well, again, liberal construction comes to save the day, and we have some protection for injured workers under the very next section of Labor Code Section 5402. Okay, so let's just summarize this so we don't get ahead of ourselves. Labor Code Section 5400 requires written notice to be served on the employer in writing within 30 days. Labor Code Section 5401 says that once the written notice or other notice is received by the employer must then immediately, within 1 business day, provide a claim form to the examinee. Labor Code Section 5402, Section A says that, 5400 and its high, strict requirement of written notice is eroded and reduced down to any knowledge, even the hearing of the assertion of a claim, constitutes knowledge, constitutes the equivalent of a written notice. Section 5402B says that once the claim form is received by the employer then has 90 days to investigate the claim. 90 days. That's Section A of 5402. No, that's Section B of 5402. Section A deals with knowledge, hearsay knowledge of the injury. Well, Section C of 5402 is what provides protection to injured workers during the 90-day time period during which the employer or the claims administrator is investigating the claim. So this is fascinating, and you must know this. This explains why so many cases are coming to you for your AOE and COE determination. So it says, this is Section C, within 1 working day after an employee files a claim form, okay, so the time period for investigating the claim, the 90-day time period, has begun. Within 1 day, meaning immediately, immediately, the employer shall authorize the provision of all treatment. Wait a minute, all treatment? I thought the claims administrator had 90 days to decide to accept or deny the claim. They do. They do. But in the meantime, while they're taking their time, taking their 89 days to investigate the claim, they must provide all medical treatment, all necessary medical treatment for each body part and each injury alleged on the claim form. It says they shall provide and authorize the provision of all treatment for the alleged injury and shall continue to provide the treatment until the date that liability for the claim is accepted or rejected. And as we learned, they have up to 90 days to do that. So they can continue, and they must continue to provide medical treatment up until the sweet date, the date after which they've taken their sweet time to decide. But it says until the date the claim is accepted or rejected, liability for medical treatment shall be limited to $10,000. So imagine we have an injured worker who's claiming injury to 4 or 5 different body parts, even more orthopedic body parts, psychiatric body parts, internal medicine body parts, okay? The employer is on the hook for up to $10,000 of medical treatment for each injury alleged. It says for the alleged injury. If they're alleging multiple injuries, that's multiple $10,000. Now, this $10,000 comes from a separate pocket book than the pocket book associated with the claim. Remember, in this first 90-day time period, the claim is being investigated. So this $10,000 comes out of a separate pocket book. So if you're the claims administrator and you have an allegation of an industrial injury, and you want to exercise your opportunity to investigate the claim for even as much as 90 days, but you're on the hook for up to $10,000 of medical treatment for each injury alleged, what would you do? What would you do during this time period? You might allow the examinee to receive maybe an initial medical evaluation at the local emergency room, or maybe 1 or 2 follow-up visits with 1 or 2 specialists, or you may allow some initial medical treatment to see what's going on with this particular injured worker. And depending on the circumstances of the facts of the case, you may then decide to accept the case. But in most cases, in order to stop the bleeding from the $10,000, right, from $0 to $10,000, in order to stop the bleeding from this particular pocketbook, the claims administrator simply gets out the denied stamp and denies the claim such that liability for the claim is rejected, thereby stopping the bleeding from the $10,000 and still allowing. So again, this is an example of liberal construction introduced into the language of all the workers' compensation laws for the purpose of protection of persons injured in the course of their employment. Now, another of the exceptions that applies to the reporting of the injury is found under Section 5403. And 5403 is probably the greatest application of liberal construction related to the reporting of the injury. It tells us that the failure to give notice under Section 5400 or any defect or inaccuracy in a notice is not a bar to recovery under this division if it is found as a fact in the proceedings for the collection of the claim that the employer was not in fact misled or prejudiced by such failure. Now, I'm not exactly sure what this means. This is legal terms. But I can tell you that I've reviewed many cases, and it's not clear what constitutes an example of prejudice to the employer. I scoured many cases related to this issue, and I was unable to find a single case where the employer was able to prevail on an assertion that they were prejudiced by the defective or faulty or even lack of notice of injury by the employee. So, in other words, a claim may be barred for failure to give notice under Section 5400 only if the employer was misled or prejudiced by the lack of notice. It's the employer that bears the burden of proving the prejudice. So dismissals under this section of the law are rare because, number one, of the broad notice that's allowed under Section 5402, the broad notice of knowledge, and the very, very difficult burden of the employer to establish prejudice. So again, liberal construction protects injured workers, and this is why we get so many claims so many cases that involve denied claims, where the employee insists to us and tells us that they told or provided notice to their employer, and now you understand how employees are protected under these sections of the law. So now I want to go over a case that illustrates these principles so that you can see the application of these labor codes in an actual and precedential case that deals with the notice of injury. Okay, so a case that illustrates many of these principles is the Honeywell case, the Honeywell versus WCAB. And this is a 2002 case that went all the way to the Court of Appeal. And this case has to deal with the disputes over the 90-day time period and disputes over the knowledge of the injury. And you can see that if an injured worker contends that they provided knowledge of the injury on such and such a date, that date could conceivably then begin the 90-day investigation period. But if the employer denies knowledge, disputes knowledge, but then later, at some date later, receives notice of the injury in some other form, such as the filing of the claim form, that those dates, the differential in those dates, are extended into the differential of the 90-day time periods. So the employee may be talking about a 90-day time period here, whereas the employer is talking about a 90-day time period here. And that difference between the termination of the 90-day time period could be critical. It could be, if the employer's position is upheld, that the employer has an additional time period with which to accept or deny the claim, still within the 90-day time period. If the employee's date prevails, then the date of knowledge prevails, then that 90-day time period is condensed. And if the employer does not reject the claim within this 90-day time period, the claim is presumed compensable. And that was what was happening with the Honeywell case. So let's review this, and I'll read directly from the case for you. In the Honeywell case, the injured worker claimed a psychiatric injury under Labor Code 5402, which means that he did not provide written notice. So the best way to establish industrial injury is under Section 5400 to provide written notice, but there was no written notice by the applicant in this case, the injured worker, whose name was Wagner. Well, the workers' compensation judge found industrial injury due to employer's knowledge. So in this case, Wagner initially prevailed and established that the employer had knowledge of the injury on such and such a date, the date that the injured worker contended or stated that the employer had knowledge. Well, the defendant sought reconsideration on the dispute that, no, we didn't have knowledge. We didn't know anything about it on such and such a date. We deny that. We refute that. We dispute that. And so they sought reconsideration. It then went to the Workers' Compensation Appeals Board, where 3 of the 7 judges sat on the matter, and they upheld the workers' compensation judge's opinion that injury and knowledge was established, that the employer did not reject the claim within the 90-day time period, and therefore the claim was presumed compensable under Labor Code Section 5402. Well, again, the defendant argued against this and said, no, we didn't have knowledge. And the matter went all the way to the Court of Appeal. The Court of Appeal reversed the decision and stated that the reporting that the injured worker provided to the employer, there was no proof of any reporting. And therefore, it wasn't until later, when the claim form was actually submitted, that date of the submission of the claim form began the tolling of the 90-day time period. And so this was a case about disputes over the 90-day time period, whereas the injured worker claimed that, hey, you didn't make a decision within the 90 days that I feel was the appropriate 90 days. You didn't make a decision. Therefore, the claim is presumed compensable. And the employer said, no, your 90 days is not our 90 days. We have a different concept of what is the 90 days. And in this case, the Court of Appeal reversed the decision and opined in favor of the injured worker. So this case illustrates the principle that reporting of the injury is critical. In the early hours, days following an industrial injury are critical to get the claim either off the ground or squashed in appropriate fashion. So what does that mean for us as qualified medical evaluators? Well, in the end, these cases that come to us, usually as denied cases, usually requiring an AOE determination from us, land on our desk and in our laps. And so let's review what is our obligation in these cases now that we know some of the sequences of events that are operative to bring these cases to us. So when these cases come to you as the qualified medical evaluator for a compensability determination under Labor Code 4060, you have a very specific and exacting and reliable set of questions and algorithms that you can rely on to come to an accurate conclusion in every single evaluation. And that begins with the condition. The question is, does the examinee have a bona fide symptomatic diagnosable condition? That's your first assessment as a medical evaluator, is there a bona fide condition present? If there is no condition, there can be no injury. If there is no injury, there is no industrial injury. This is where the medical determination from you is critical to establish the presence or the absence, first of all, of a condition, okay? And examinees who present with no condition have no injury, and therefore they have no industrial injury. Now, if a bona fide symptomatic diagnosable condition is identified on your physical examination, then the question becomes, does the condition rise to the level of an industrial injury? Meaning, does that condition cause a need for medical treatment, or is it causing disability in any way? If so, your question then becomes the AOE determination. So you see this sequence of events, and I'm going to share this with you in schematic format in just a minute. Your next question becomes, okay, so we have a condition. We have a condition that rises to the level of an injury. Is it reasonably medically probable that this injury condition, that the symptoms or the condition that the examinee is presenting with, is it reasonably medically probable that that condition arose out of the employment due to the mechanism of injury or due to the job place duties described to us by the examinee? This is the AOE determination. The AOE determination comes after the determination as to the presence or absence of an injury. So it goes like this: injury first, industrial injury second. Without an injury, there can be no industrial injury. So let's take a look at this in schematic format. So in schematic format, it looks like this. And this is the medical decision making that you can employ in your very next evaluation. Number one, is there a bona fide symptomatic diagnosable condition present? Now, in the case of a normal physical examination, the medical decision making stops right here, because without a bona fide symptomatic diagnosable medical condition, there can be no industrial injury. So when the answer to this question is no, then the algorithm goes in this direction and there is no industrial injury and your job is over. Now, on the other hand, if you do find a bona fide symptomatic diagnosable condition, then you've got some decision making to go through. And your next line of questioning is, number one, does the condition cause disability, or does the condition cause a need for medical treatment? These are the two criteria required to establish an injury, as injury is defined in California workers' compensation. If the answer to those questions are no, then in this case, if the condition does not rise to the level of an injury, meaning it's not causing disability, there can be no industrial injury. Or if the condition does not cause a need for medical treatment, then again, there can be no industrial injury. Now, if the answers to those questions are yes, then you still have some medical decision making to do, and then you need to then go through your AOE determination. At least at this point in your algorithm, you have injury established by establishing the need for medical treatment, or you have injury established by establishing that the condition is causing disability. You then need to continue on by assessing whether or not this injury could have arisen out of employment. Okay, so this is the causation algorithm, and it will fail you never. This will work for you every single time, no matter the behind-the-scenes circumstances that are operative to bring you this evaluation. So doctors, I hope this helps you. You know, as they say, there's 1,000 stories in the big city, and in workers' compensation, that certainly is the situation, because we can sit with 1,000 examinees and hear 1,000 different stories about what it is that brings them to us in the face-to-face evaluation. And I've shared with you in today's session some of the behind-the-scenes sequences of events that cause disputes over the presence or absence of an industrial injury. And each party, in attempting to carry their burden of proof, looks to us as the qualified medical evaluator to provide an opinion on the medical issues involved in the case. And that basically devolves down into whether or not the examinee is presenting an industrial injury or not. Now, I've given you a simple algorithm, and we've reviewed this over our last two sessions, and you can rely on this simple algorithm. It basically begins with a determination as to whether or not the person sitting before you, first of all, has a bona fide symptomatic diagnosable condition. Do they have any medical condition at all? If you fail to be able to identify a medical condition, then of course there can be no industrial injury because there's no injury. Now, if you find a bona fide symptomatic diagnosable condition, then you've got some work to do. You then need to establish, does that condition rise to the level of an injury? Meaning, is it expected to improve with medical treatment? Does it need medical treatment? Has it had medical treatment? Is it causing disability in any way? Does it rise to the level of an injury? And if it does not rise to the level of an injury, then there can be no industrial injury because there's no injury. If it does, you've still got some work to do. You still need to establish if that injury condition could have arisen out of the workplace duties. And we've discussed many of the situations and even some actual cases that give us some direction in establishing our own AOE opinion. Now, in our next session, I want to spend the entire session going over several specific case examples. We're going to go over case after case that illustrate these principles in actual examinees' cases. And we'll see how the judges and the courts and even the Court of Appeals deal with these difficult issues so that we can better learn how to handle these cases when they present to us for our determinations. So I want to thank you for taking the time to join me on today's session. I look forward to being with you on our next session as well. And I want to thank you for your commitment and your dedication to excellence in this important work that we do. For now, this is Dr. Perry Carpenter, wishing you best of success in your career as a qualified medical evaluator.